So let's talk about something really interesting. A single law in India's fight against corruption that's got everyone debating. Is it a shield for the honest, or is it actually a sword for the corrupt? We're diving deep into the battle over Section 17A of the Prevention of Corruption Act.
Okay, let me just frame this for you with one simple but pretty powerful question. What if the police needed to get permission from the government before they could even start looking into government corruption? Think about that for a second.
Yeah, that one question is really at the heart of this 30-year-long struggle. On one hand, you've got this genuine concern for protecting honest officials. You don't want them so scared of frivolous investigations that they stop making decisions, right? That's what they call policy paralysis. But then, on the flip side, how do you ever hold powerful people accountable if their own colleagues get to decide whether an investigation even starts?
And this whole thing didn't just pop up overnight. Not at all. To really get what's happening with Section 17A today, we've got to go back. We're talking about a 30-year tug of war between the government and the Supreme Court over this exact issue.
So, take a look at this timeline. You can see a very clear pattern, right? It's like a legal tennis match. 1997, the Supreme Court strikes something down. 2003, the government brings it right back, but this time as a law. 2014, the court says nope and strikes that down too. And all of that sets the stage for 2018, when the government tries for a third time with Section 17A. It's a fascinating back and forth, so let's break it down. Okay, so this whole saga kicks off with something called the Single Directive. Now, this wasn't some big law passed by Parliament. Nope. It was just an executive order, basically an internal memo. And it told the CBI, India's top investigation agency, hey, before you investigate any senior officials, you have to come ask us for permission first. Well, the Supreme Court was not having it. In the famous Vineet Narayan case back in '97, they basically said two things. First, you can't just use an internal instruction to get around a law passed by Parliament. That's a no-go. But the second point was even more important. They said this rule creates a privileged class of senior officers. You're shielding them, but not their junior colleagues. And that, they ruled, violates Article 14 of the Constitution, the fundamental right that says everyone is equal before the law.
But the government wasn't ready to throw in the towel. After the court struck down their executive order, they thought, okay, you don't like the order? Fine. We'll make it a formal law. And that's exactly what they did in 2003, putting the rule into Section 6A of the DSPE Act, which is the law that governs the CBI.
And guess what happened? Fast forward to 2014, and a 5-judge bench of the Supreme Court strikes it down again. They were pretty unimpressed. They basically said, look, this is just the same unconstitutional idea wrapped in a new package. It still creates this unfair divide between different ranks. And the court had this incredible line saying that corrupt officials are all birds of the same feather, and the law has to treat them all equally, no matter how high up they are. Which, finally, brings us to today, and to the government's third, and honestly, its most cleverly designed attempt yet to create this protective shield. And that is Section 17A of the Prevention of Corruption Act. So what exactly is Section 17A? Well, it's even broader than the previous versions. It says that no police officer can conduct any kind of inquiry or investigation into any public servant for stuff they did as part of their job, unless they get prior approval from the government first. Now, you can tell the government really did its homework here. They designed this thing specifically to try and get around the Supreme Court's earlier objections. First, it's a formal law, not an order, so that's the Vineet Narayan problem solved. And second, and this is the clever part, it applies to all public servants, not just the senior ones. They were trying to head off that whole privileged class argument at the pass. Of course, this new law was challenged in court almost immediately. Everyone knew this was heading for a massive constitutional showdown. But after years of waiting, the result was, well, something nobody really saw coming. Because on January 13th, 2026, the 2-judge bench hearing the case delivered a split verdict. That's right, the 2 judges just could not agree on whether Section 17A was constitutional. This left the entire law, and really the whole fight against corruption, hanging in complete limbo. And this split verdict, it's fascinating, because it's not just a technical legal disagreement. It reveals 2 totally different philosophies, 2 competing visions for how accountability should work in India. It's a huge deal. So here's the breakdown. On one side, you have Justice B.V. Nagarathna. Her take? Section 17A is fundamentally unconstitutional. It has to go, period. But on the other side, you have Justice K.V. Viswanathan. He argued that, hey, the law's goal is actually okay, but it's missing a crucial piece. independent oversight. Justice Nagarathna did not mince words. She called Section 17A old wine in a new bottle. For her, this was just attempt number 3 to push the same unconstitutional idea that the court had already shot down twice before. Simple as that.
Her reasoning was crystal clear. She said, look, even though the law says it applies to everyone, let's be real. In practice, who does it shield? The senior officials who are making the big decisions and recommendations. So we're right back to that same inequality problem. Plus, she pointed out, it's a huge violation of natural justice. You can't have the government being the judge in a case against itself. And by blocking even a preliminary look, the law just forestalls justice at the threshold. It stops it dead in its tracks.
But Justice Vishwanathan had a completely different perspective. He said, wait a minute, the core idea here, protecting honest officials from being harassed, that's actually important. If we just scrap the whole law, he argued, it's like throwing the baby out with the bathwater. The goal is valid, even if the execution is flawed. He really focused on this idea of policy paralysis, that chilling effect where good officers are too afraid to act. His point was, just because a law could be misused doesn't automatically make it unconstitutional. So what's his solution? A middle ground. Let's keep the shield, but let's take the power to approve investigations away from the government itself. Instead, he proposed, let's give that power to an independent body, like the Lokpal, an anti-corruption watchdog, and their decision would be final. Okay, so all this legal back and forth is super interesting, but what does it actually mean in the real world? Right now, with the judges split and the law still on the books, what's the actual impact on the fight against corruption?
Well, this number really tells the whole story. It perfectly illustrates the real-world stakes we're talking about.
And get this data came from the government itself, submitted right to the Supreme Court. It shows that in more than 41% of the cases where the CBI asked for permission to investigate an official under Section 17A, the government just said no, flat out. The investigation was dead before it even got started.
So, where do things stand right now? Well, Section 17A is still the law. The government still holds all the cards when it comes to approving or denying these investigations. The whole case has now been passed up to the Chief Justice of India, who has to put together a larger bench to finally settle the question. But let's be clear, a final decision? That could still be years away.
And all of this leaves us with one massive critical question. With the law stuck in this constitutional limbo and a final verdict nowhere in sight, who really has the upper hand right now in India's long battle against corruption? Is it the investigators or the investigated?